In calculating whether a defendant is a persistent violent felony offender, does time spent incarcerated before conviction count? To find out, you have to read People v. Hernandez, but it's 25 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People v. Hernandez. The citation for this case is 2025 New York Slip Opinion 00904, published by the New York Court of Appeals on February 18th of 2025. The issue in this case is in determining whether a person is a persistent violent felony offender, does pre-sentence incarceration act to toll that 10-year limitations period? To understand and appreciate what's going on in this case, the background that's helpful to know is that New York's sentencing guidelines, New York's sentencing scheme, says that for each individual crime or each individual conviction, there's a certain sentencing range that's available to a judge who's going to sentence a person. In fact, there's certain things a judge must sentence a defendant to, depending on what the conviction is for. For a first offense, there's one sentence range. For a predicate felony, there's a second sentence range. But for a persistent violent felony offender, that's kind of like the 3 strikes rule in New York. If you have 2 previous violent felony convictions and you're convicted of a third violent felony conviction within 10 years on the street, where the defendant has spent less than 10 years in society outside of prison walls, then the defendant is eligible to be sentenced as a persistent violent felony offender, and the sentencing range is massive. Usually it's life on the back end, and it's a large number on the front end. It's usually, 12 to life, or 20 to life, or 25 to life. But determining whether that 10-year period, how that 10-year period is calculated, is what's addressed by the statute and what's addressed by this case. Under Penal Law Section 70.04, it says that under 70.04(1) sub 4, except as provided in subparagraph 5, which we're going to get to, sentence must have been imposed not more than 10 years before the commission of the felony of which the defendant presently stands convicted. That's sub 4. But sub 5 says, in calculating the 10-year period under subparagraph 4, which we just read, any period of time during which the person was incarcerated for any reason between the time of the commission of the previous felony and the time of the commission of the present felony shall be excluded, and such 10-year period shall be extended by a period or periods equal to the time served under such incarceration. So that's the subject of this particular case, and what's gone on in this particular case is that the defendant in 2015 robbed a Manhattan convenience store at gunpoint and assaulted the proprietor of the store. A jury convicted him of robbery, which is a violent felony offense, in 2017. Before sentencing, the prosecution, filed a predicate felony statement using 2 prior violent felony convictions and the relevant dates of incarceration that extended the 2-year period, according to them, showing that the defendant had been on the streets for less than 10 years between the first felony conviction through the final felony conviction, therefore giving him 3 felony convictions within 10 years, according to the prosecution. The defendant said, hey, wait a second. That first felony conviction, I was incarcerated before I was convicted. I pled guilty, I was incarcerated for 9 months, and then I was sentenced, and that pre-conviction time should not be counted toward my 10 years. If it's not counted toward my 10 years, then I'm outside of the box, and I'm not a persistent violent felony offender. So it matters a lot. The Supreme Court held that under the plain language of the statute, all 3 of these convictions fell within the 10-year period. It was told by the time that he was incarcerated between the commission of the first offense and the commission of the last offense. And the appellate division affirmed that finding, holding that the 10-year, that this person was a persistent violent felony offender. It goes to the Court of Appeals, and they agree with both the Supreme Court and the appellate division. They say the language here is not ambiguous. The language here is clear that if a person, that any incarceration period between the commission of the first offense and the commission of the last offense is excluded from that 10-year calculation. So even though the first conviction was 1990 and and now this is being sentenced in 2017, because the defendant was not on the streets for 10 years, a lot of that time was subject to incarceration, tolling, the defendant is considered a persistent violent felony offender and subject to that enhanced life on the back end sentencing. They say this is not an ambiguous statute. There's a strongly worded dissent by Judges Rivera and Wilson. They say that the tolling provision should exclude pre-conviction post-conviction time. But once again, the holding here is that it does include all the time that's between the commission of the first offense and the commission of the last offense. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.